will be making a statement, after which we'll be having statement from both Mr. Nandalal and Ms. Ishiras. Yes?
Thank you. Morning, everyone.
Morning.
The first statement I will read as follows. Mr. Granger has moved from blood on his carpet to egg on his face in the way he governs the country. Threats and indecisiveness is the order of the day. From whichever way the ineptitude of government is examined, it is the lives or economic well-being of individuals or groups of Guyanese that is at stake and is being placed in jeopardy by a government that is insensitive, cynical, and discriminatory in nature. This has been a long-established and indisputable fact. Corruption. Another attack has been launched on the private sector by Mr. Granger, branding them corrupt and of aiding and abetting corruption. This is the ultimate manifestation of deception on the part of the Granger administration. By way of this attack, Mr. Granger is seeking to deflect public attention from his camp, where corruption is like a cancer eating away at the sinews of every branch of his administration. He has finally admitted that his government has failed in the fight against corruption because, in effect, it has become a partner in white-collar crime. East Coast troubles. In August 2013, Mr. Granger, while addressing a gathering at Buxton Friendship, called for an inquiry into the East Coast troubles. That call was made more than 3 years ago when Mr. Granger was in the opposition. Now he is in government and has the power to set up a presidential commission of inquiry, but has failed to do so. Yet in a matter of 18 months, he has set up over a dozen commission of inquiries. He has studiously avoided setting up a commission of inquiry to deal with the so-called East Coast troubles. How come this particular commission of inquiry is no longer a priority? Or was it just a red flag that was being waved to whip up political sympathy for his 2015 elections campaign? Clearly, this is another manifestation of a failed president who likes to pretend that he's standing on the side of the law and the Constitution, but who, at the same time, has embarked on a path to criminalize public policies pursued by the previous PVPC administration, the bottom line of which is aimed at poisoning the political atmosphere in Guyana. Confrontation with the DPP's chambers. By seeking to divert attention from the torrent of criticisms facing his administration over the past months, and with the mainstream media becoming increasingly critical of the APNU-AFC, the Granger administration has resorted once again to witch hunting of former PVPC presidents and government ministers, threatening the use of special prosecutors outside the ambit of the DPP's chambers, on the ground that prosecutors from the DPP's chambers were not favorably disposed to prosecuting government-inspired investigations, which the DPP's chambers recently debunked as a lie coming from the Attorney General's chambers. This is clearly another manifestation of interference by the executive in its attempt to sideline, undermine, and to usurp the legal and constitutional authority of the DPP's chambers. It is as disgraceful and shameful as the previous attempts were at the public service, the police service, and the judicial service commissions. Next is the government decision to launch a nationwide campaign to revoke scores of firearm licenses. This move by government must be viewed from two perspectives. First, as a distraction, and second, as an act of desperation aimed at shoring up government's failed crime-fighting policy. But the most ridiculous aspect of this move by government is the rationale given for proceeding in this direction. They claim that there have been, quote-unquote, hearing stories, and that licensed firearm owners, quote-unquote, may be renting their firearms to criminal elements. Is this the basis on which this campaign is going to be launched? Hearsay? Should such a campaign be evidence-based rather than speculation-based? What scientific research or studies have been done to justify such a move on the part of government? The links between guns and violence is a complex matter. Will the approach by government be permissive or be restrictive? What the government has done to justify its intended action is to politicize rather than professionalize the issue of gun control by introducing language such as gun violence prevention. The government must answer the question whether its approach will see changes in the Firearms Act to make the legislation more restrictive and or to bring the laws in line with United Nations resolutions to regulate civilian ownership of small arms. Studies in a number of countries have shown that lots of guns do not necessarily mean lots of violence. No studies have been done in Guyana to prove this is the case. If the government wants to address illegal firearms in Guyana, the first thing they must address is the missing 237 weapons, among them semi-automatic weapons that were issued by the Guyana Defense Force in 1979 to the Ministry of National Mobilization and Development. These included 50 pistols, 100 magazines, 20 Berettas SMCs and accessories, 15 M70 rifles, 10 879 guns, 11 light machine guns, all of which were signed for by one Comrade Skeet on behalf of that ministry. In addition, 7 Smith & Wesson weapons were issued on May 18, 1976 to Mr. Robert Corbin, the then Parliamentary Secretary to the Office of the Prime Minister. Who knows whether this practice has not recommenced with the assumption of the PNC to office closed in the APNU. After all, we too are hearing stories, and maybe this is what is happening again. Incidentally, we heard that the Acting Commissioner of Police issued a number of firearms bypassing the Firearm License Approval Board and all other established procedures. Mr. Granger and Mr. Ramjatan must be honest with the nation and clean the blood on their carpet. They still have time to do that. Since Mr. Granger was in the opposition, he expressed concerns about guns and the crime situation. He claimed he had the solution when he had none. His crime-fighting strategy, if there is one, is not working, contrary to what he claimed over the weekend. But Mr. Granger, unfortunately, cannot say that the plan is not working. in the same way that the police cannot say it is not working either. They therefore have become trapped in their own propaganda. Fear is the main driver of gun ownership, and there is tremendous fear today among the citizens of Guyana. In addition, in Guyana today, there's a high stress level, an abundance of trauma, a deepening social crisis, an increasing number of people at risk, and an inordinate number of mental health issues. Mr. Granger has to address these problems comprehensively. Piracy. Did I hear Mr. Granger say that piracy is down because of, quote-unquote, increased aerial patrols? Aerial patrols where? Were Guyana-owned aircraft allowed to fly over Surinamese territory? How many fixed-wing patrols were conducted in 2015 and 2016 to date? Were these aerial patrols part of a wider responder network, or were they standalone patrols? If it was the latter, then they were useless. What Mr. Granger said about aerial patrols was plain and simple government propaganda. Finally, on crime. Mr. Granger said that the speed by which police is closing investigations must be compared to the unacceptable rate at which crimes are being committed. Mr. Granger misses the point. The issue here is not the speed by which police is solving crimes. The larger question is the speed by which crime prevention is taking place. This is an important area where the government has failed. The President also failed to mention how many cases have been lost for want of prosecution. How many accused were granted bail by the courts, and how many have been sentenced to prison. Crime prevention is the problem, not crime solving, with dead bodies strewn all around us. Thank you.
There you have your statement now, Mr. Nandlal. Statement.
Thank you very much. Erskine May's Parliamentary Practice, 12th edition, on page 234, states, and I quote, "The chief characteristics attaching to the office of the Speaker in the House of Commons are authority and impartiality. The opposition has had cause, unquote, the opposition has had cause to repeatedly complain against the Speaker's conduct in the National Assembly. The sitting of the National Assembly of the 4th of November 2016 provides another such occasion. It is now public knowledge that at that sitting I was prohibited from speaking and participating in the business of and subsequently expelled from the National Assembly by the Speaker. I am an elected member of the National Assembly. My right to speak and participate in the business of the National Assembly is grounded in the supreme law, the Constitution of Guyana. This issue was elaborately addressed by Chief Justice Chang in a case filed by me as Attorney General on the 27th of November 2012, when the then joint opposition gagged then Minister of Home Affairs, the Honorable Clement Rohi, from speaking in the National Assembly. In the course of his 34 pages judgment, Chief Justice Chang at page 27 posited thus, I quote, "It is the view of this court that Mr. Rohi's right in the Assembly, right to speak in the National Assembly, derives from his office as a member of the National Assembly and not from his office as an executive minister. Thus, his right as an elected member of the National Assembly must be concomitant with his constitutional duty to speak for and to represent his electors in the National Assembly, who in turn have a concomitant right to be so represented. It is here apposite to note that Article 9 of the Constitution expressly provides, sovereignty belongs to the people, who exercise it through their elected representatives. End of quote, as a quote from Justice Chang's ruling. On the other hand, the Speaker is not an elected representative of the people, but is elected by the members of Parliament and hold office at their pleasure. His status, role, and function lack the constitutional underpinning and security of tenure which elected members enjoy. The word parliament is derived from the French infinitive parler, to speak, and the Latin derivative parli, which means speak. In any democracy, Parliament is the highest forum for discussion and debate. A speaker's role is to maintain order with a view to facilitate and encourage debate, not to curtail and frustrate it. The notion which seems to have permeated the 11th Parliament, that the Speaker can capriciously interfere with a member's right to speak and to influence the content of those speeches, and the whimsical requests for evidence and sources from members during the course of their speeches in relation to matters that enjoy public notoriety and which are published widely in the press, is not only a gross abuse of power by the chair, but it is also an unlawful interference with a member's duty to represent his constituents and a violation of the constituent's rights to be represented by his elected representatives. This abrogation of the Constitution and parliamentary norms and practices strike at the heart of our democracy. The doctrine of comity rotates upon the axis of reciprocity. It is not a one-way street. The prohibition of an elected member's right to speak without good cause, as I have pointed out, is a violation of the Constitution. Moreover, his expulsion from the precincts of the House. These are not matters which are to be treated lightly. The video of my presentation has since been made public for the world to see. I did not behave disorderly or contumaciously. I did not disrupt the proceedings of the House. The Honorable Speaker offered me an option: withdraw my statement or take my seat. In compliance with his order, I chose the latter option. Yet I was banned from participating in the remainder of the proceedings. Yet still, the Speaker wanted more. He next expelled me. The Speaker fell hopelessly into error when he did so. I committed no act or created no situation which would warrant the use of that exceptional power. An elected member of the National Assembly does not sit in the Assembly at the pleasure of the Speaker. The matter is compounded by the lack of impartiality. It is public knowledge that ministers of the government are given days and sometimes weeks to produce documents. Oftentimes they never do, but there is no reprimand from the Speaker. In the very sitting, Mr. Bulkan was granted leave by the Speaker to produce certain documents until the next sitting of the National Assembly. The public is also aware that Minister George Norton failed to produce the controversial rental contract for the premises at Sussex Street, rented to store drugs and pharmaceuticals, when requested to do so in the National Assembly. The Speaker gave him permission to send it at a later date to the National Assembly. 2 weeks hence, he did not do so. I wrote the clerk to remind him of the minister's breach of his undertaking to the National Assembly to produce this document. The clerk informed me in writing that he will write the minister to remind him. Only then did the minister send a copy of the contract to the clerk's office. Again, not a murmur of objection or admonition from the Speaker. However, I am ordered to instantly produce a newspaper to which I made reference during my speech. My request for an hour to do so is summarily dismissed by the Speaker, and I am ordered to withdraw the statement unless I can produce the newspaper instantly. As it turned out, I found the article to which I was referring. It vindicates what I said in my speech. In this entire saga, the fact that the opposition came to the National Assembly that particular day, prepared to discuss a completely different agenda, and therefore was unprepared to discuss the President's speech, conveniently escaped the Speaker. Had I known that I was coming to speak on the President's speech, I would have equipped myself with the necessary newspaper clippings upon which I wished to rely. The agenda was changed, as you all know, immediately prior to the commencement of the sitting. In the end, the lack of impartiality and the abuse of power are axiomatic. I have here the article to which I made reference. It's an article published by the Kaichor News on the 23rd of August 2016 under the heading, Government Pays BK 5.7 million on a simple threat letter. Bolkan's photograph is here. In the article itself, written, I believe, by Kiana Wilborg, a reporter of the Kaichor News, it says this. In an interview with this newspaper, the politician, that's Bolkan, explained that indeed the court said that BK International should be compensated after its contract for the management of the Hackbush contract was arbitrarily terminated. Bolkan said that the company, however, never moved to the court for compensation. He revealed that by way of a letter, BK made a claim for over 10 million US to the government. The Minister of Communities said he's not sure what or how or when the issue of BK going before the court to make his claim was manufactured. And that is where I got the information from a Kaichor News newspaper, which a reporter, I believe it is Kiana Wilborg, spoke to the Minister of Communities, and that is what he said. This newspaper article was never refuted by the minister, and I pointed that out to the National Assembly. Yet the minister stands in the Assembly and with a straight face says that he never made such a statement. And this brings me to the second component of what I wish to speak on. It is the tendency of ministers of this government to lie in a barefaced manner to the public and to the National Assembly. We saw Minister Norton lie in relation to the bond contract at Sussex Street, as a result of which he had to apologize. Here you have Minister Bolkan lying to the National Assembly, saying that he never said this, yet it was published and he never refuted it. And I wrote several articles after that in which I highlighted this particular statement attributed to Mr. Bolkan, and he never once refuted it. Then I have here an article which was a letter to the press, published on the 27th of October in the Stabrook News, where I recited a litany of lies told by the Attorney General to this country. I listed them. One, when he said that he was not requested to prepare a report for Cabinet in relation to the compulsory acquisition of the two properties at Carmichael Street. Stabrook News had said that he was ordered to do so. He wrote a letter saying he was never ordered to do so. A week after that, Secretary to the Cabinet, Mr. Joseph Harmon, at a press conference confirmed that he was ordered to prepare a report to Cabinet. Then I listed that Mr. Williams lied when he claimed that he discovered the Rhodesia judgment was obtained against Guyana. And I outlined that he must know that the Rhodesia judgment was obtained against Guyana while he was in the opposition. So when he said that he discovered it when he entered government, was a blatant lie. Then his public contention that the PPP administration caused Guyana to be blacklisted by CFATF and FATF is another lie. The nation knows that Guyana was placed in that precarious position because APNU AFC used their one-seat majority in the opposition in the 10th Parliament to vote down the various bills tabled by the PPC government, which were required to be passed in compliance with CFATF, FATF recommendations. Thirdly, I wrote, when the BK International multi-million US settlement in relation to Hackbush became public, and it was revealed that this government agreed to pay $5.7 US on a mere letter threatening litigation, the AG incredulously told a fabricated story that the PPP government had agreed to settle this matter. and to pay BK International that sum of money. I called upon him then to produce a scintilla of evidence that the PUP government had agreed to settle this case. To date, he has been unable to do so. So again, I wrote about this mere payment of this money on a mere letter. This again was the 27th of October. No denial coming from Minister Bulkan. And then I pointed out again, Mr. Williams lied when he said, when he was caught trying to compulsorily acquire 2 private properties on Carmichael Street, his concoction this time was that the PUP government had begun the process to compulsorily acquire these properties. Since compulsory acquisition is a document-driven process, I again challenged him publicly to produce an iota of evidence that the PUP have started this process. To date, of course, he has been unable to do so. Then, in Saturday, November the 5th, newspapers, DPP says AG lies about state prosecutors shunning highly political cases. So we have a new phenomenon developing now in public office, in governmental office, where ministers are standing before public fora, both in and out of the National Assembly, and are lying left, right, and center with impunity. So I hope in the new code of conduct that we are told the government is working on, that they will list the publication and peddling of lies by ministers as an ethical wrong. Because how else will the nation be able to rely upon statements that they make when they lie profusely? I will stop at that point in time. And
All right, thanks, Sam. We'll ask Mr. Shearer now to
Good morning. I know that on November 4th, and the representation of the press was very thin by 1 o'clock in the morning. And that is regrettable, but I understand was maybe a long session. But I think I have to go back to what began the controversies, and that was the fact that Private Members' Day was supposed to be held on November 4th. And those of you who were there at the October 27th sitting may have remembered that the audit paper was circulated that morning, around 1 o'clock in the morning, which showed that all our items, 3 motions we had, had been given precedence on the audit paper. In fact, the government, on the morning of October 28th, 1 o'clock in the morning, had absolutely no business on the audit paper. On November 1st, we got a supplementary audit paper having a motion to debate President Granger's address. This was odd, and we tried to ascertain where was this going to be debated. We were told that then the fight began outside of Parliament when was Private Members' Day. Was not resolved as of Friday when we went to Parliament, and there was a meeting with the Speaker, myself, Chief Whip Amna Ali, and the clerk. Minister Amna Ali's computation of when is a Private Members' Day would have put us at the 48th sitting. I remember Friday was the 45th sitting. And if you remember the schedule that we were given, November 17th, November 28th for presentation of budget, December 5th for the debate to start on the budget, the 48th sitting would have fallen on December 5th, the day of the budget. And therefore, our Private Members' Day would have rolled over sometime into January, February 2017. We found this highly unacceptable. As an opposition, we have had one day in December 2015. You will recall, some of you who do cover Parliament, that we were supposed to have a sitting in October. That was our day. And that is when the Prime Minister deferred for 54 days and then another 2 weeks and so forth until we got our day, the middle of December, just a little, the cusp of going into Christmas. And then we had January 12th, May the 14th, August the 4th, and then November 4th. So in the whole debate and the discussions prior to, Minister Amna Ali, on behalf of the government, refused to give us our day. And the speaker said that you could compromise, we could share the date and have Mr. Granger's, the motion on the President's address, debated between 2 and 4 o'clock in the afternoon, and the rest of the day would be ours. She absolutely refused, said she had 16 members for the debate. My conclusion is that the whole reason why this took place wasn't only to knock us off Private Members' Day, but the fact that the address by the President was on October 13th. A government motion has to have 6 days. A private member's motion has 12 days. That there was ample time for the government to bring a motion calling for the discussion on the address by the President. By putting it on November 1st, or Sunday, November 1st, it did not have the 6 days. And the fact that the Speaker suspended, waived the standing order to allow them to not have the 6 days, which is a prerogative of government, but it mustn't be abused either. I believe firmly that the insertion of the debate on the President's address was deliberate, a ploy to ensure that the Private Members' Day would not take place. In the end, after much discussion, we demanded that we have a day before the budget, and that we demanded that November 21st be our day. We believe that the items we had on the agenda, particularly the parking meters and the Jubilee Durban Park Development Project, were of great interest and public importance to the Guyanese people, and they should have been heard. And let us hope on November 21st they will be heard, and we will have a private member's business having precedence over government. That is one component of the scenario that took place on November 4th. However, we noticed previously that the Speaker has a penchant for demanding documents and where they are from and so forth. And I want to just remind you of the handbook and the standing orders that basically says the reason why a member can quote from any document, he can give a source, and he makes it available to whom? Not to the Speaker, but to the parliamentary reporters. And the reason why he does that is the reporters want to make sure that they accurately quote you in the Hansard, in the minutes of the proceedings of the sitting. So there's no requirement of you submitting a document or quoting exactly for the purposes of the Speaker. Furthermore, my colleague Anil Nandalal quoted from Erskine Mays, and he's quoting from the 12th edition. I have the 23rd edition, so I'm a little more up to date than you are there. But this is what it says, and both sections are there. On page 443, it says, there is no rule to prevent members not connected with the government from citing documents in their possession, both private and public, which are not before the House, even though the House will not be able to form a correct judgment from partial extracts. So again, it is, you are allowed. You may be able to say, as Mr. Nandalal said, it was in several newspapers. I can't remember the exact date, but it's a public document. It's been there out in the press, and I'm prepared to submit it tomorrow, the next day, or as Mr. Balkan, ministers of the government, they'll do it at the next sitting, whether the sitting has been named or not. And the next sitting, when an important issue like anti-infect and the use of it, of 100 litres being bought and brought into this country, 100 litres, by the way, sounds like a little bit, it's not a lot, because it is then mixed with water at millions of cubic feet and so on, and therefore it's quite a lot of anti-infect in the country. So the fact that on a matter of great public importance, the minister could say, you bring it in the next sitting, which is November 21st, so that Mr. Nandalal was in order to have said what he said, as far as I'm concerned, and with Erskine Mays. So under the handbook and the standing orders, the reason why you hand your extracts out or your documents or your sources is for parliamentary reporting purposes. So when the Dr. Jagdeo had said in one of his speeches, he was referring to an affidavit which Mr. Carl Greenwich gave in 93-94 to do with the levels of poverty. He was able to extract from that, and that in the transcription, the parliamentary reporters then asked for the document to get the correct details and the correct extraction from the document. It was never a question that this wasn't allowed. So that this use by the Speaker is a rather new one of, if you can't produce the document there, it's unacceptable if you're in the opposition, that you have to have your documents on you. In fact, the attempt to quote from the laptop, which Mr. Nandalal did, he quoted 5 different, headings from various newspapers. That was not acceptable. We find this development in the Parliament extraordinarily worrying. And again, I go back to Erskine Mays. First of all, as Anil Nandalal correctly said, the chief characteristics attached to the office of the Speaker in the House are authority and impartiality. And to go on, confidence in the impartiality of the Speaker is an indispensable condition of the successful working of procedure. And many conventions exist which have as their subject not only to ensure the impartiality of the Speaker, but also to ensure that his impartiality is generally recognized. And we are having a problem in this Parliament with that. Obviously, the actual procedural issue with Mr. Nandalal is something I want to raise with you. And that is that some of you may have been in Parliament in the last Parliament, when the opposition banged on the tables for half an hour and the Speaker got up and they disobeyed that, and the Speaker then, who was Mr. Trotman, then suspended the sessions over and over again. There was a period that this behavior continued. Not one person was censored, not one person was named by the Speaker. The standing orders are very clear on how you deal with disorder. And in the case in the 9th Parliament, there was a lot of disorder, a lot of total disrespect for the Speaker and for the House. And all it was meant to do was to prevent the government then from speaking and having the opportunity to defend itself. In this Parliament, there has not been one occasion of disorder, not one occasion on the part of the opposition. We find it strange that every time there's a sitting, whenever the government is rather noisy or insultive and heckling and so on, the Speaker turns to us and reprimands us. And this is beginning to be very irritating for our MPs, because we feel that we are always the subject of his attention. Further than that, though, the actual incident that happened, under the standing orders, the Speaker really cannot tell a member to exit. In other words, he gave the member a choice. Can you either withdraw or you sit? The member chose to sit. He then says the person must be silent for the rest of the sitting, and then says you could leave the sitting. These are not ways in which...
Could leave. Not could leave.
Yeah, you should leave. Yes, sorry. That the use of this language by the Speaker is, again, worrying, because the standing orders don't give him such powers unless the member was being absolutely disorderly. And the Erskine Mays goes into a whole series of incidents of where a person is being disorderly. A member saying, I choose to sit and not withdraw, is not considered disorderly.
I comply with his order.
It is not considered disorderly. In fact, the Speaker may have been offended, and we're sorry for his ego, but he may have been offended that the person chose to not withdraw. However, it is not a breach of parliamentary procedure. To go further to that and tell him he can't speak and that he should leave the House is really taking a certain position that the standing orders do not provide for. Any attempt to remove a member from a House, suspend him and or has to come with a motion that the House discusses, that the House deals with. And that is why when we were in government, and the members on the other side, led by the late Mrs. Deborah Backer and the then Leader of the Opposition, Mr. Granger, sat and watched it all. we brought a motion to the Speaker to try to have him name a number of the members who were the ringleaders of disrupting the House over and over and over again. And it didn't go through. And therefore, the members were allowed to behave as they did. So this action by the Speaker, and worse yet, when the members of the PUPC got up to join and give solidarity to Mr. Nandalal, he then threatened contempt of all of us. Contempt on what grounds? This, we believe, are very unhealthy and distasteful developments in the House. Very unhealthy and distasteful. And whilst one cannot, and the standing orders and the practices to do with the Speaker are rather sacrosanct, at the same time, the Speaker cannot be so capricious in his treatment of members. He has to be impartial. He must have an even hand. If he's going to demand documents quoting source and everything, and when I tried, as our members were leaving, to quote from him the source, because I was given a laptop that had the article which Mr. Nandalal is now referring to, he said it's of no importance, the matter's over. He's not interested in knowing what is the quote I was giving or trying to give. And so we are very disturbed about this development. And of course, I do believe that there will be repercussions from this in terms of how the government will react and how the Speaker will react, how the public will react, and how we will react as the opposition to this rather unsavory and what we believe is an undemocratic approach to our right to speak, our freedom to speak in the House, particularly as the member was not referring to a private document, he was referring to public documents, the media, which were never refuted by the ministers concerned, both the Attorney General and Mr. Bulkan. So we want to put that on record, that these developments in the House we believe are unhealthy. One, that we don't have our private members' day. We've only had 4 in 17 months, and that we feel that the opposition members of the House are being muzzled in having their time before the House, and then the particular incident with Member Nandalal, which we believe is a breach of his democratic right to express himself in the House, particularly in this instance where he was not being disorderly whatsoever.
Thank you. There you had 3 statements. I'll ask your question. State your media house name and question.
Vanessa Ryan, Citizen Report. A couple of questions. Ms. Sherry, you mentioned repercussions, and you cited Arsene May's reference to the members of Parliament having confidence in the impartiality of the Speaker. That said, what is the opposition's, the PPP's position going forward in terms of a possible action against the Speaker, maybe, or a letter? What's the action? What's the next one?
Our first reaction is to have this press conference, and let's leave it at that for now.
All right.
Yeah. We will have time to continue because there's something called waiting on responses. And let's see, as the Speaker threatened contempt of all of us, let's see what's going to happen in this week. Our first response is to go to the press and give what has happened.
Yes, you mentioned the firearms in the National Assembly last week. Minister Cotton stood up and said that when the President talked about firearm licenses, what he was referring to was persons with multiple firearm licenses, and that's what that's what they're going after. So you have a response to that.
But did the President say that?
It doesn't matter whether it's multiple or single licenses in the hands of an individual. The fact is that those individuals, one has to assume, went through the normal process,
Exactly.
and they were approved by the Firearm License Approval Board. Police background checks were done, and all the procedures were followed. To revoke those licenses whimsically or arbitrarily without just cause is a matter which I have experienced happened before, and those persons have gone to the courts, and the courts have ruled that the firearms be reinstituted. So I don't know what is the real intention of the government.
Final question, Mr. Anwar. You mentioned the ministers and their lying, their face lying, don't you? In the House. What is the redress that the opposition can move towards?
Privilege,
Well, the Privileges Committee
privilege motion.
is the mechanism that is available to deal with lies published in the National Assembly. We have Norton, who will be going there, and the Volcan may be going there too, in relation to the lie which he published last Friday.
Okay. Other questions? Yes, sir. Yes, you took objection to a suggestion that the private sector was corrupt. Sir, do you deny that the private sector is corrupt?
Where's the evidence? The evidence is what is important in these, making these public accusations and allegations and claims. Too often, people make these statements, they don't provide any evidence. There are some in the public who just gobble this thing up and repeat it 100 times different places as though it is true. And this is the problem sometimes that we have, with government officials, especially at the level of the president, making statements when there's no evidence to,
The GRA,
back up what was said.
the GRA has repeatedly moved against people in the private sector, businessmen, for smuggling. Many have appeared before the court. There have been cases of people being charged, and there are two cases I know going on now for money laundering, gold smuggling. And there have also been the cases of income tax dodging on some cases where publicly stated that in the case of private sector employers have attempted to bypass whatever happens at the wharf to pay their due VAT or duties. Wouldn't you consider those acts?
My argument is to point in one direction without pointing in the other direction is problematic. We are using the political argument, as Granger is, by seeking to deflect attention from what is happening in his camp, with the mountain corruptions, activities that are emerging, and there's more to come. And by the way, I noticed the Kaitian News and some of the newspapers in particular have taken off their pages what is happening at GCOM. All these other corrupt exercises, they're not talking about it anymore. I don't know why that is happening. But the point I want to make is this. Pointing in the direction of the private sector without admitting that I am having problems in my camp too is a double standard.
The next thing I want to
No, but
So there may be instances of corruption in the private sector. There may be instances, but you can't use that as an excuse
Exactly.
not to speak about what is happening in the public sector, in the government circles as well.
Just to add to what GS has said, and that is that in what way is it helpful to our country, to the business community, to the economy, to castigate and throw an accusation on an entire sector No, undoubtedly there are private companies that have been found for all sorts of wrongdoing. You work for a private company, Mr. Adam Harris, and there have been questions there too. So that,
He worked for two private companies.
oh,
you know.
two, okay, I
Well,
missed that
two.
one.
So
And
he's
this,
receiving a double
so,
pay.
in what way does it help the country? I have no problem with the president or anybody saying this one has been charged and that one's been charged and that. But to take everybody and lump them together is unhelpful, and it is damaging to our country. Because when your headline at Kayach or any of your headlines come out, private sector of Guyana is corrupt, what message are you sending internationally and globally? There is no rhyme and rhythm to the thought process behind these comments. In what way does it help us? In what way does it help fight corruption itself by saying the private sector is corrupt? So, I mean, my reaction is, you know, this is just knee-jerk, and I believe, too, the point that Rohit made earlier in his first statement is that fear. Part of these things, you know, private sector is corrupt, this outfit corrupt, we're going to charge these people, we're going to come after these people, we're going to do this. The threats to us in Parliament by Patterson, they're going to lock us up. The Prado is like, you know, the presidential candidates now in the United States talking about Trump, talking about locking up Clinton. And you've seen the media response to that, as this is a shock to the American media that a presidential candidate was saying. We have that daily in the Parliament whenever we meet. The media doesn't get shocked in this place about such things. They take it for par for the core. But the issue is that this is driving fear. So if I take everybody and call them Ali is corrupt, I'm really sending, as someone said on the television the other night, American television, about a dog whistle. The dog whistle, they particularly used a particular thing in relation to a particular thing that Trump did, but I'm just paraphrasing and saying a dog whistle to people and saying, you better watch yourself. You better watch yourself. Toe the line. And I think these are very dangerous, dangerous trends that have emerged in our country in terms of our democracy. Dangerous trends.
Sorry, and one last thing I wanted to ask had to do with the issue of special prosecution, which, to my mind, isn't irregular, it's been going on, and the DPP has to issue a fiat. I remember it was spoken about the Mark and Cup trial where Sanjeev Dadin,
Not me.
would you issue the fiat?
I was a special prosecutor with Sanjeev.
But the DPP had to issue that fiat. Similarly in this case, where you said it's a usurpation of the office of the DPP or something, or attempt to usurp the power of the DPP. With the DPP having to issue this fiat, how does the appointment of special prosecutors attempt to usurp the office of the DPP?
Well, let me explain to you, Havana. Firstly, it is what happened to the Auditor General Office, and I wrote about this profusely. The consistent sidelining and emasculation of the authorized constitutional agencies by this government. So the 23 years of Auditor General reports have been rejected by this administration. The Auditor General is the constitutionally authorized personnel to audit the public accounts of Guyana. Those constitutional provisions have been tossed aside, and the Minister of Finance unilaterally hires a set of auditors to audit public accounts, when the Constitution resides that responsibility exclusively with the Auditor General's office, and any private person must be hired by the Auditor General's office, or the authorizing of the hiring must come from the Auditor General's office. In like circumstance, the DPP, by Article 187 of the Constitution, is responsible for the initiating of criminal charges. Of course, you can have private criminal charges as well. But by and large, the Constitution vests the initiation of criminal proceedings in the DPP's office. So the Mark Bench Cup charge that you spoke about was initiated by the DPP. The police did the investigations, sent the file to the DPP for advice, and the DPP advised and drafted the charges which were laid in the court. Datadin and I were hired by the DPP to prosecute charges recommended by the DPP. Apply that now to the situation at hand. These are charges that are not coming from the DPP. In fact, the sentiments coming from the DPP is that there is insufficient evidence to institute these charges.
No charges have been laid.
No, the charges that they plan to lay.
They can.
But I don't know whether they can. They are hiring prosecutors. One has to assume that the prosecutors are going to be hired to prosecute charges. And the charges, from all indications, do not seem likely to emanate from the DPP office.
Exactly.
And that is why I said that they are creating a parallel legal system to the constitutionally established criminal justice system. And that's the vast distinction from the DPP issuing a fiat. The DPP normally issues a fiat in relation to charges filed by the DPP or advised by the DPP. And then if the victim, the virtual complainant, they wish to retain a lawyer of their choice, they write to the DPP, and the DPP grants that fiat, a permission. This is not what's happening here. This is a confrontation between the executive and the DPP, where the Attorney General fabricates another lie to say that the DPP's office is reluctant to prosecute politically inspired offenses or offenses that have some political content, basically accusing the DPP office of abdicating its constitutional responsibility, and the DPP says a total lie. And she lists instances where her officers have prosecuted political offenses or political offenses that have some political attachment or content to it.
Any other
I just want to say one thing, that the media must be very alert and take note of what is happening in Guyana. These incidents have to be connected to each other. If we see them in an isolated way, we will see the forest but not the trees. What appears to be emerging in Guyana in a stealthy way is a form of governance that is eroding gradually a number of constitutional bodies. Interference, for example, in the service commissions. The president, I read in today's newspaper, said that Duncan remains suspended. Doesn't care what happened in the courts. Next, we have this example that Anil just gave about the confrontation with the DPP's chamber. And in today's headline of the Chronicle, stating that the DPP's chamber is under investigation.
Oh, Jesus, I didn't even see that.
Yes, it's under investigation. And then you have the Auditor General's office. So just take some time off, those journalists who have very good cognition skills, to step back and watch what is happening in the country. Today is for one individual or group of individuals, tomorrow it may be for others. And the media has an important role to play in these matters. If you cover it up, then you're covering up crimes which you as journalists ought to be watchful about. So the press and the media has an important role to play in these matters. All that I'm saying is be sensitive to these issues, or else you will be in dereliction of your duties as a journalist committed to, as they say, fourth or fifth estate of saying what is really happening in the country.
And you get a good idea if you read Unruly Horse every week.
I'll get your
There's a constant recitation of these excesses.
Mr. Rowley, you talk about crime prevention strategies. Can you say what are some crime prevention strategies the government should take to prevent crime? And Mr. Nanlal, the actions like the speaker, do you deem this as an act of dictatorship?
A what?
Well, you know,
Dictatorship.
it's interesting that you raised that question, because I think it was last year, Mr. Granger called a special meeting when there was a spike in the crime situation with his kitchen cabinet to formulate a crime-fighting plan. We have never heard anything subsequently afterwards. It went to the police, it went to Mr. Ramjatan, it went all over the place, you know, like a stray dog looking for some rubbish somewhere. We never heard anything subsequently, so speaking for myself, I don't even think they have a crime-fighting strategy. What they do is to meet every week at this National Security Council, chaired by Mr. Granger, and there it is dictated what the police should be doing or what the army should be doing. This is where Dr. Luncheon, I think, made a commentary over the weekend about politicization of the military and the police.
Probably cabinet meeting at Niagara.
Yes, but he was speaking also in a broader sense. So, first let's start off on the premise that the government has no crime-fighting strategy. Forget all the talk. That's their job to talk and to create the impression that there is something there. But if there's something, well, this body has recently been triggered. This is the Oversight Committee for the Security Sector. We will ask that the strategy be brought there, if there's any at all. So let's examine it. We, over the years, I'm talking about the PVPC administration over the years, have put out our own strategy. It's published. It will need another press conference to enumerate on the different elements of this crime-fighting strategy. We had a conference at the, what you call it?
Convention Center.
The Convention Center, out of which a number of recommendations were established, and the Cabinet agreed to set up a special committee to, on the question of interpersonal violence, to pursue the recommendations. We even took to Cabinet a request for some money to hire a consultant to assist this committee in respect to implementing the recommendations that came from the conference at the Convention Center. Regrettably, government changed, and it threw out all those things. We had a National Commission for Law and Order. It was set up years ago. They disbanded that. So all those initiatives that were taken by the PVPC administration, because it was PVPC originated, they have discarded them, and they're starting all over again. Save and except with the citizen security, which they couldn't avoid doing because that was IDB sponsored project, with the exception of a few tweaks here and there, as Mr. Ramjatan
Citizen security.
usually say. Citizen security, IDB project, that's something that originated with the PPPC too.
When you take away the right of an ordinary citizen to speak, you are taking away from him a fundamental constitutional
Right.
freedom. When you take away a member of parliament right to speak, in the National Assembly of a country, you are committing the gravest constitutional violation. More so when you do that in absence of a situation that would warrant the exercise of a power to discipline the member. Right? So, it is an authoritarian,
That's the word.
authoritarian act to deny a member of Parliament who has a constitutional duty to represent the people of this country his right to speak and his duty to represent his constituents. Look, for example, and I'm going to examine it in great detail for this weekend, this sub judice rule that the Speaker uses as an absolute bar to discussion. The sub judice rule is completely misinterpreted by the Speaker and used as a guillotine mechanism
Yes.
to stop absolutely the discussion of any legal proceedings. The sub judice rule is simple. It says that one cannot discuss out of court a matter that is pending in the court in a manner that may prejudice the outcome of the proceedings. That is it. You must not discuss it in a manner that will prejudice the outcome of the proceedings. Now, the standing order vests in the Speaker the discretion to determine whether your discussion will prejudice the outcome of the proceedings. But the Speaker never allows you to start the discussion. The Attorney General, who unfortunately knows very little, stands up and blocks any attempt to discuss any pending case. Can you imagine that I can stand in front of Freedom House and discuss a case, or I can stand at the corner of Camp Street and discuss a case, but in the highest discussion forum of the land, I can't do so? Does that make sense? And that is the type of travesty that passes. And I refuse to believe that the Speaker knows, that the Speaker doesn't know better. He has a PhD in law, and I respect him for that. But the learning is not, he's not exhibiting that kind of learning in his ruling. He stops any discussion whatsoever using the sub judice rule, abusing the sub judice rule,
Yes, abuse.
and using it to gag discussion. That is not what the sub judice rule says. And I'm going to write it elaborately for the media this weekend.
Can I suggest that the media look at 387, page 387, the same Erskine May's 23rd edition, matters awaiting judicial decision. This rule does not, however, apply where a ministerial decision is in question, and that was what we were discussing on Friday night or Saturday morning, and may in any case be waived at the discretion of the chair. So exceptions have, for example, been made on matters before civil courts which relate to ministerial decisions on or certain concern issues of national importance, matters which have no likelihood of coming before the courts in the reasonably foreseeable future, and matters which, though touching upon issues which are sub judice, are unlikely to affect any judgment. So the old sub judice has gone through many reforms globally, because obviously the issue of ministerial indiscretion or ministerial decisions being questioned, and that is where Parliament scrutinizes government, so that there is no, it's not sacrosanct once a matter is in court. He isn't even allowing you to refer that there is a matter in court and to quote from it, which is absurd, absolutely absurd.
Encouraged by someone who should dissuade him. If he's falling into error, the responsibility is upon the Attorney General, and it is the Attorney General that is initiating the shutdown.
And I just want to remind the media was there the last Parliament. Remember the big fights with Trotman, with Mr. Ramjatan about sub judice. Remember that in the 9th and 10th Parliament, the issue of sub judice was under serious fights by Mr. Ramjitan and Mr. Trotman, and led to an amendment to the standing order that made it not as, how do you say, black and white. Prohibitive. And in fact, the Trotman as Speaker also was pressured by the then opposition to do with sub judice matters. So they had open sesame to say and whatever they wanted about court matters. But the Erskine Mays, which guides us on when, and the British parliamentary rules, although we're not a Westminster, strictly Westminster Parliament, that these experiences of the British Parliament, and which are in these records, are there to guide us when we're unsure, when our standing orders are not detailed and clear and stuff like that.
Our standing order says that
Yeah.
at the end.
Yeah.
Okay, ladies and gentlemen, thank you all very much.